ordinance, which is similar to this language. But for 6 weeks, there was not a day that someone didn't come up to me during the campaign and say, "Are you gay?" And I'm not gay, but if I was gay, I'd be gay. But anybody who wants to say that there's not a discrimination factor is wrong. It didn't bother me. I told them what I was. I am who I am, and that's the way it is. But I'm concerned about us taking a certain class and trying to make something out of something that isn't that big a deal. And, people should not be discriminated against for any reason whatsoever.
Absolutely agree with that, Representative. And I don't believe that there was any part of my testimony that stood contrary to what you just said, and I appreciate that.
Okay, thank you.
Are there other questions of the witness? Thank you, sir.
Thank you, Mr. Chairman.
Others opposed to the...
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries of Missouri. We share the same concerns that you just heard from the chamber. It's not that, and you heard a list of some of our members read. I want to point out that the representative was not representing any of those companies, and in fact, those companies do have policies, as you heard. Some of those companies, I'm not sure, I haven't checked with them on their policies, but I'm sure they have adopted policies, and those are company policies. We have not, as an organization, taken a stand either for or against this particular policy. I can tell you that we have a concern about creating a new statutory protected class. The reason is because that invites another line of lawsuits. And that is our concern, is creating a new protected class that invites another way to sue employers. That is a problem. Also, the definition of motivating factor in this bill really is misleading, because it makes you think that you are providing some protection to employers, but actually what you're doing is codifying a very low standard of contributing factor that is the standard today. The Missouri Human Rights Act, pardon me, the Federal Human Rights Act requires a standard of motivating factor for discrimination cases, and this uses the words motivating factor, but then it describes contributing factor by saying that the discrimination has to have played any part of or played a role in the decision to dismiss the employee. So actually, while it uses the words motivating factor, please don't be misled into thinking that you're codifying the federal standard for discrimination, because it's not. It's actually codifying the very low standard of contributing factor. So for those reasons, we have to be on record in opposition to the bill, and be happy to answer any questions.
Representative May?
Permission to inquire.
Go ahead.
I just have a question. You talked about, but what if it is one of the motivating factors? It's hard to prove discrimination as it is. And because it's hard to be in the heart and mind of a person. So they'll use because I've been in employment for a long time. And I had a manager that, was firing all of the African American women in the department when he came on. And I was the steward at that time. So I went after him. But what I'm trying to tell you, it was hard because he used other things. He made the work environment difficult for them. So he used other things, saying, well, you didn't get this done fast enough, or this wasn't done, So the contributing factor was that the only way I was able to get him removed is I had to go to the outside EEOC and said, look at his record. Everybody he's ever fired was African American black women, and even though the company didn't want to look at that, you understand?
Yes.
So what I'm trying to say is, we play with these words, motivating or contributing factor, when we know that the person is discriminating and we don't want to do anything about it. And that's my concern, even though if it's a contributing factor, if it's the motivating factor, either one, if it's a small, if that is even one or part of the reason for it, then we have a problem. And I think that the companies, I know it's very hard, but you have to create an environment in which you will not tolerate that for your managers or whatever.
certainly we agree with that, and discrimination should never be tolerated. I think in the case that you cite, you should be able to prove that was a motivating factor. Obviously, they were motivated by discrimination if they're getting rid of everyone who is in that class. And that is a motivating factor. You've proven that. So even if it were a motivating factor, you could have brought that case under a federal standard of motivating factor and been able to win that. So I think you proved the case. Right?
So let me ask you this, one other question. What's wrong with contributing factor?
I think contributing, well, the problem that we see with contributing factor is that just by virtue of the fact that you are in that protected class, can shift the burden of proof to the employer to prove that there was something that played absolutely no role at all. And in that case, it's hard for the employer to prove that because you can see that person was in that class that it played no role at all, even though it didn't. And that's very difficult. I think the burden of proof is what the real problem is. And I think that's why it's not part of the Federal Human Rights Act, and why the Federal Human Rights Act requires it to be a motivating factor. And that's what we're trying to do, is get to the federal standard of discrimination. But this particular language just codifies that lower standard, and we would like to see it be the federal standard. We realize we passed that bill a couple of times, and the governor's vetoed it a couple of times. And we may not be able to get there.
I hope not, because I know that if you know the history of Missouri, we had to come to a contributing factor for a reason. And I think that's why the language in the Missouri law says contributing factor instead of motivating factor. Thank you.
Other questions for this witness? Thank you, sir.
Thank you.
Others in opposition?
Good morning, Mr. Chair, members of the committee. My name is Tyler McClay. I'm General Counsel for the Missouri Catholic Conference. We wanted to go on record in opposition to the bill. I want to affirm, first of all, that it's the position of the Catholic Church and the Missouri bishops that no one should be fired simply because they're gay or transgendered. Our concern with the bill has to do with primarily with the public accommodation provision in the bill. As the committee and the body of the House considers amending this law, I think we need to consider the dignity of all the workers in this state. And when we look at the changes that have been made in other states to the public accommodation provisions, there have been bakers and photographers who have been charged with discrimination for refusing to participate in a same-sex wedding ceremony. And it seems to us as a church that there needs to be space in a pluralistic society for people of faith who do not agree with same-sex marriage to be able to opt out of having to participate in that procedure. And I'm thinking particularly of someone like Elaine Huguenin, who is a photographer in New Mexico. She was asked to photograph a same-sex ceremony. And at the time, New Mexico did not recognize same-sex marriage. And she said, I cannot do that. And she was charged with discrimination by the Human Rights Commission of New Mexico, and she was found guilty of discrimination and was ordered to pay the attorney's fees for the same-sex couple that she refused to provide services for. The case then went up to the New Mexico Supreme Court, and this summer the New Mexico Supreme Court said that as a matter of law, she did not have the right to opt out of doing that, notwithstanding her religious convictions. And the concurring opinion, the judge says that this was a price of citizenship, that she had to do this. And it seems to us as people of faith that, none of us can walk out of this building and stop being a Republican or a Democrat or a Catholic or a Protestant or whatever. We need to have a space in our society for people to be able to take their faith outside the building into their workplace, not outside their home. I mean, certainly people that are gay are going to be gay outside this building, outside their homes. We just think as we look at changing the law in this area, the law can be a blunt instrument. And there needs to be some fine distinctions made in some of these areas. And we are certainly not calling for Jim Crow laws. Absolutely not at all. Gay people should not be denied a room at a hotel. They should not be denied a meal at a restaurant. They should not be denied basic services at a hospital. We're not calling for that. But there are situations where an individual that's running a business is going to be faced with a quandary where they, as a matter of conviction, cannot participate in something. And there needs to be space for them to be able to say, I opt out. And that's really all we're talking about here. I've got written testimony that I'll provide to the committee that lays out some of these concerns, and I'd be happy to answer any questions. I know that Mr. Brockman has met with Archbishop Carlson. We'd be willing to visit with him ourselves at the Catholic Conference, talk to him about it, work with Representative Engler on this, and I'd be happy to visit with any of them and discuss this further.
Questions?
Mr. Chairman.
Representative Weber?
Mr. Chairman.
Go ahead.
So when we talk about public accommodations, we're talking about things in the stream of commerce, right?
Right.
Now, in the 50s and 60s, there were people that used a religious argument as a argument to say that we shouldn't be required to serve blacks at a lunch counter, correct?
Agreed. True.
Okay. And they said it was they had a religious, moral problem against the mixing of races. Structurally, how is your argument any different than that?
It's different in that is a basic service. In other words, they were not being asked to endorse something by offering us, by serving someone a meal. We're not saying that businesses should be allowed to opt out of serving a meal. But when you talk about having to participate in something, a wedding service, for example, and that's really what we're talking about. I mean, we're talking about a small carve-out for that kind of thing, where having to participate in that is going to implicate rights of conscience. And
Okay, but we agree that even serving a meal, in part of, probably even today, but certainly back in the 50s and 60s, there were certain white people that thought serving black people a meal was a right of conscience too, correct?
Possibly,
You know that's
it's
correct,
possible.
right?
Yeah,
We know that's-
I presume that's what they argued, sure.
Right. And so, would you support them under their rights of conscience being able to, and religious objection, being able to not serve a black person a meal?
No.
Okay. So we're talking about the stream of commerce. We're not talking about performing religious ceremonies, correct?
No, we're talking about photographing, providing a cake, providing a floral arrangement.
We're talking about things that they've offered the public.
Correct.
They're not the photographer who only takes pictures at a particular church, right? If they're the church photographer, we're not talking about that person. We're talking about somebody who advertises publicly their services to anyone and then says, except for this particular group of people, right?
Right.
Okay. So it seems to me like you're really, really trying hard to have it both ways, because you said that you didn't think that people should be discriminated against for being gay. You're not against people having lodging and being served food, all of which theoretically somebody could have a moral conscience objection to. And then you picked out one particular area and said that, except for this area, like wedding photography. I don't understand the difference either legally or theologically or philosophically between wedding photography and as a business and another business. Why is that one deserving of more protections?
Let me give you the example of, I think his name is Jack Phillips. He's a baker in Colorado. He was charged with discriminating because he wouldn't bake a cake for a gay wedding ceremony. He said, I'm happy to bake you a birthday cake. I will sell you brownies, I'll sell you cookies. But when you talk about me having to come to your wedding and service your wedding, I just can't do it. It's a matter of conscience. And it goes to a deeper level. It's not, because it ends up being, it could be implicitly or directly an endorsement of that. And the other thing about putting it into law like this is that you then,
So wait,
let me finish,
you don't
please.
think, you don't believe that, because you said earlier that you thought people should be able to serve food, so you don't think that.
Well, I mean, a basic meal, I'm talking about a meal at a lunch counter. I mean, I'm talking about a cake for a wedding, where you're going into a wedding and facilitating that wedding and using your creative talents to endorse and be part of that wedding.
Okay.
That's what I'm talking about. And what the concern that we have with the bill is that you're putting into law, and you're going to have the power of the state used to compel people to do something against their conscience, which really is an infringement, in our opinion, on human dignity. Because religious liberty, at the end of the day, is about human dignity and not being compelled to do something that violates human dignity.
So laws banning segregation are against human dignity.
No, I didn't
Yeah,
say that. I
you
didn't
just
say
said
that.
using the power of the state to compel somebody to do something they think is morally wrong. And people definitely think that at the time segregation was morally justified. So you believe that was a violation of human dignity?
No, I don't agree with that.
Okay. Flagging my last question. This is the Arizona argument, isn't it?
The Arizona argument, as I understand it, has to do with, it's a legal argument, has to do with neutral laws of general
We
application.
don't know laws, so
Right.
that's appropriate.
So, right, I mean, I'm not advocating for that as part of this bill. What I'm saying is, there's got to be a way, and I think what the Arizona bill would do, if you have a neutral law of general application, as you know, you're an attorney, then the state can overcome religious objections if there's a compelling government interest, right? I mean, that's the law. And I think what the Arizona law is intending to do is to allow people to have the defense that they refuse to do something on religious grounds. And that's all that the Arizona law, as I understand it, and I haven't looked at the nuance of it, but that's my understanding of what the law in Arizona is intended to do. I think the problem with the law in Arizona is that it would allow business owners to deny people at the level of service in any situation. In any situation.
Like you've been advocating for.
I'm advocating only in a certain circumstance where it's an endorsement of something, gay marriage, same-sex marriage. I mean, this is, we have had, traditional marriage has been the definition for thousands of years, and we're changing the law. I mean, we're going into a new area right now, okay?
But serving, a business is not endorsing something by providing a product. I mean, you agree with that, certainly, right?
Not necessarily. No, I mean, I
A
agree
business
with
endorses, I mean, every time a business involves in a business interaction, they endorse whatever the person is doing.
No, I don't think that's true.
I don't
think,
get it, right?
No, I don't think that's true.
Okay. I think you're having a hard time articulating your position because I think your position is pretty much indefensible. And I think it's pretty much impossible to lay out a legal argument that allows what you want to have happen without defending segregation, which is more or less what you've done. So
I disagree with that.
I know you disagree with that because you don't like.
That's not what I'm saying at all.
You don't want to be there. I know you don't want to support segregation.
I don't support segregation.
I know you don't, but your argument does, and it's impossible for your argument legally, theologically, or morally to be any different than that. And that's why I think you keep running into trouble trying to explain it, because you're trying to explain something and argue for it at the same time. So to say we disagree is probably an understatement. Thank you, Mr. Chairman.
We've had a fascinating discussion here, but we're getting way off the basis of what we're supposed to be talking about in this law. I'll entertain questions, but I want them to stay with the